This case takes a shocking turn from the very first moments in court. A woman accused of shooting someone she claims to love stands before a judge who isn't buying the contradiction for a second. What follows is a courtroom exchange filled with stern warnings, a second chance at freedom, and ultimately, a decision that could determine whether she spends years rebuilding her life or decades behind bars. Stay with us, because Judge Boyd is about to deliver some brutally honest truths that leave absolutely no room for misunderstanding.
So here's the thing. You can't shoot somebody and then say you love them. We don't shoot people we love. So your relationship with her is over. And whether or not she wants to be in a relationship with you, that's besides the point. I'm not going to allow you to have any contact with her. Do you understand? Your recommendation?
Yes, Your Honor. She was previously ordered safety but failed to self-surrender, and probation feels that she could benefit from the substance abuse program due to her drug program. Problem.
All right. So I regret that I didn't know that you didn't surrender to safety, because if I would have known that, something else would have been done. You're looking at, if I don't continue, you're looking at up to 20 years in the prison. You understand?
Yes, ma'am.
All right, I'll deny the motion. CR 6214, State of Texas versus Amberly Perez. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Dwight Chumley.
And are you Ms. Perez? Since I'm showing you the discovery acknowledgement, have you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Perez, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? And you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Counsel, has your client been able to provide you with any defenses to this offense?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, there's to be a $1,500 fine, affirmative finding of deadly weapon. State recommends deferred adjudication. There's an affirmative finding of family violence, and there's to be no harmful or injurious contact with Jessica Hernandez. Next, I'm showing you outside the plea bargain agreement. The state is recommending that your deferred adjudication be for a term of 7 years. There'll be a TAP evaluation, 150 hours of community service restitution in the BIPP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence? I'm sorry, you're gonna have to speak up.
No contest. State offers State's Exhibit 1 and its attachments into evidence.
No objection.
Are you proceeding with sentencing?
This is where the hearing takes an important turn. Notice that the plea agreement included a provision allowing certain limited contact, but the judge immediately signals that he has concerns. In criminal cases involving violence, especially where a firearm is involved, the court's primary responsibility is public safety and victim protection. What's striking here is that the judge isn't focused on the defendant's intentions or feelings. He's focused on the actions that brought the case to court in the first place. Do you think a victim should ever be allowed to resume contact with someone who seriously harmed them, or should courts always step in and draw a hard line?
Yes, Your Honor.
All right, so just so the parties know, I'm not going to agree to this no harmful or injurious contact with Jessica Hernandez. So if that's something that's going to break this plea bargain agreement, I'm not doing it.
It's not, Your Honor. That's fine, Your Honor. I told her that she is going to have no contact with her at all. And she
Yes.
has
All right. So here's the thing. You can't shoot somebody and then say you love them. We don't shoot people we love. So your relationship with her is over. And whether or not she wants to be in a relationship with you, that's besides the point. I'm not going to allow you to have any contact with her. Do you understand?
That statement may be one of the most memorable moments in the entire hearing. You can't shoot somebody and then say you love them. It's simple, direct, and impossible to misunderstand. Judges often try to cut through emotional arguments and focus on behavior, and that's exactly what's happening here. Regardless of how either party feels, the court is making it clear that actions have consequences. The judge is effectively ending any possibility of continued contact and prioritizing safety over personal wishes. It's a reminder that criminal courts aren't relationship counselors. They're tasked with protecting victims and enforcing the law.
All right, this is what the court is going to do. It's a $1,500 fine, probated, 7 years deferred adjudication. There's an affirmative finding of family violence. There's an affirmative finding of a deadly weapon. There's to be no contact with Jessica Hernandez. And when I say no contact, that means no cards, no letters, no contact whatsoever, no sending a letter saying, I'm sorry, or any of that. Do you understand? There's to be 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. The BIPP course. Do you have any children? What do you do for a living?
I'm a home care provider.
Not anymore. I don't allow people on probation to be a home health care provider. So how far did you go in school?
Dropped out like in 9th grade.
Why?
I didn't have my credit, so we dropped out.
That makes no sense. Nobody has credits to graduate from high school in the 9th grade.
I have enough to pass my degree.
All right. There's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to ask for regular reporting by Zoom or in person. There's to be regular UAs. And I'm going to want field visits 2 times per month. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court?
No.
And probation, I'm serious about no home health care, no minors, and I'm going to do no unsupervised contact with minors as well. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you view that document with your attorney, and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, thank you.
At this point, the defendant has received what many would consider a significant opportunity. Instead of a prison sentence that could have stretched for years, the court granted deferred adjudication. That means she avoided a formal conviction. For now, but only under strict conditions. The catch is that every condition matters. Missing appointments, violating restrictions, or failing drug tests can quickly bring someone right back into court. Deferred adjudication isn't freedom without consequences. It's a chance to prove that rehabilitation is possible. The question now becomes, will that opportunity be used wisely, or will it eventually lead to a much harsher outcome?
Calling 2022 CR 6214, State of Texas versus Amberly Perez. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Eric DeWalt, I represent Ms. Amberly Paris.
And are you Ms. Perez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
All right, off the record for a moment. You all are going to have to move down there if you want to talk. No talking behind the court reporter while the court is on the record. And you'll need to ask the deputies to move your client. We're back on the record. Are you the same Amberly Perez who was placed on deferred adjudication in 2022 CR 6214 for the offense of aggravated assault with a deadly weapon on September 13th, 2022 for a period of 7 years?
Yes, ma'am.
All right, state.
Violated condition number 38 in Bexar County, Texas. The defendant, Amberly Perez, then and there failed to submit to drug testing as directed by the court officer, supervision officer for the month of June, August, and October 2023 in violation of condition number 38.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objections?
None, Your Honor.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Your Honor, it's for the benefit of the safety.
Your Honor, that is the proposed agreement. We are also in agreement. I know Ms. Amberly is ready to make a change in her life, and we'd ask that she.
Listen carefully to what the judge is doing here. Instead of immediately imposing a prison sentence after the probation violation, he's putting the responsibility squarely back on the defendant. This is a critical moment because courts often look at whether someone is willing to take accountability for their future choices. The judge isn't simply asking if she wants another chance. He's asking whether she's truly prepared to change. That's a very different question. Many defendants promise they'll do better, but the court wants evidence through actions, not words. If you were in the judge's position, would you give another chance or impose the prison sentence right now?
Please be given this chance.
All right, Miss Amberly, here's the thing. You know yourself better than I do, better than your counsel does, the state does, and probation does. You need to ask yourself if you're going to be serious about this probation and if you want to successfully complete it. Sometimes people will say they want to successfully complete probation and they do not do it. What ends up happening is they continue to use, they don't report. So I'm going to give you a choice. I can sentence you to 5 years in the prison today, or you can go to safety.
Safety.
All right. State your excuse. And probation, is this your recommendation?
Yes, Your Honor. She was previously ordered safe P but failed to self-surrender, and probation feels that she could benefit from the substance abuse program due to her drug problem.
All right.
This exchange reveals something many viewers may overlook. The judge openly acknowledges that he wasn't aware of a previous failure to surrender to the treatment program. That's unusual, because judges don't often place responsibility on themselves during a hearing. But notice what follows immediately afterward, a very serious warning. The defendant is being reminded that the original charge carries a potential sentence of up to 20 years. In other words, this second chance comes with a crystal clear message. Any future violation could eliminate the court's patience entirely. The stakes couldn't be much higher at this point.
So I regret that I didn't know that you didn't surrender to safe P, because if I would have known that, something else would have been done. And that's my fault for not speaking to probation before then. If you fail to follow the court's orders and come back before me, if the state is able to prove up any allegations, you're looking at, if I don't continue, you're looking at up to 20 years in the prison. You understand?
Yes, ma'am.
All right, I'll deny the motion, alternate amend conditions to include safety, and she's to remain in custody until transfer. And I'm going to extend her for 1 year. Is there anything else?
Nothing from defense, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am.
All right, good luck to you.
Your Honor, may I be excused?
Yes.
What a remarkable courtroom case. We watched a defendant charged with aggravated assault using a deadly weapon receive an opportunity that many defendants never get: deferred adjudication instead of immediate prison time. We also saw how quickly that opportunity can be placed at risk when probation conditions aren't followed. Throughout the hearing, Judge Boyd repeatedly emphasized accountability, victim protection, and personal responsibility. His message remained consistent from beginning to end. Choices have consequences, and every second chance comes with expectations. In the end, rather than sending the defendant directly to prison, the court chose to extend supervision and require treatment, while making it absolutely clear that future violations could result in a sentence of up to 20 years behind bars. The case serves as a powerful reminder that rehabilitation opportunities exist, but they must be earned through compliance and commitment. What do you think? Did the judge make the right decision by giving her another chance? Or should prison have been the outcome after the probation violation? Let us know in the comments below. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.